Auer. What is this thing called Auer deference? Well, I just talked about Skidmore deference, and I just talked about how the Supreme Court ended Chevron deference, so it only makes sense that I'll discuss now Auer deference. It's a fairly simple, fairly straightforward administrative law concept. The history of it isn't overly complicated. It kind of just moved in one direction. So given that it's pretty simple, it should take me less than an hour to finish talking about it. See what I did there? Anyhow, so Auer deference kind of actually originated in 1945, being started off as Seminole Rock deference. This was in the case of Bowles versus Seminole Rock, written by Justice Murphy. And you can kind of see how the time was different back then. You had 9 Supreme Court justices appointed by President Franklin Delano Roosevelt. They all had a very pro-administrative agency mentality. Well, generally speaking, there was one dissenter in that case, and it was Justice Roberts. But for the most part, you had a bunch of FDR appointees on the court who supported administrative agencies, wanted to give them wide discretion. And so they originally established Seminole Rock deference, which is basically just the original Auer deference. So then we fast forward 52 years to 1997 in the case of Auer versus Robbins, where Justice Scalia writes the majority opinion. He's joined by every other justice, 9-0, and he affirms Seminole Rock and states that, yeah, agencies get a very high level of deference when they interpret their own regulation. So for admin law students, keep in mind that if the agency isn't interpreting their own regulation, Auer deference doesn't come into play. It's not relevant because Auer deference is only for its own regulation. If they're interpreting a statute back in the day before Chevron got overruled, it would have been Chevron deference. But when they're interpreting their own regulation that they themselves wrote, they can be eligible for Auer deference. Now, originally, as it was understood, this was like the highest level of deference possible. And it kind of makes sense when you look at it from a policy standpoint. It was the agency that wrote the regulation. It was not Congress. It was not a state legislature. It was not the court. It was not the President of the United States. It was the agency. So the idea behind it, the policy concern, is that the agency knows best what they meant. It's like if you say something, you know best what you meant when you said it. Nobody else should get to come in and give their own interpretation and have that interpretation be the one true one. You're the authority on what you say. The agency is the authority on what their regulation says. So then we fast forward about 14 years and we see that the Auer deference framework is starting to get weaker. You had the case of Talk America versus Michigan Telephone Bell Company. This was again written by Justice Scalia in a concurrence. The majority was not written by Scalia, but Justice Scalia's concurrence was very interesting because he actually expressed, he was the original author of Auer. He expressed concern that maybe Auer deference isn't exactly right, that maybe we shouldn't have it. Imagine that, Justice Scalia changing his mind. But yeah, he was questioning it. He thought it gave too much discretion to agencies, too much discretion to the federal government, and it actually encouraged agencies to write vague regulations because the idea is that if the court sees that the regulation is vague or ambiguous, they're more likely to defer to the agency because the agency should have known what it was saying when it wrote the regulation. So Justice Scalia is like, I don't know if this is right. Maybe we should go back on it in this Talk America concurrence. Then a year later, in the 2012 case of SmithKline Beecham Corp., this was written by Justice Alito, and he again kind of built off of that Scalia concurrence where he said, well, look, Auer deference is contingent on some conditions. If the agency's interpretation of their regulation is clearly erroneous, then it's inappropriate to give them Auer deference. Like, yes, we are going to draw a line. The agency's not just going to get Auer deference for nothing. We have to make sure that their interpretation actually makes some sense, that it's not nonsensical. And there was actually a dissent from some of the liberal justices in that case. But yeah, Justice Alito is kind of tempering Auer deference in 2012 in that case. And still, there's kind of this thought among the federal district courts, the federal circuits, that Auer deference is the highest level of deference possible. It's even higher than Chevron, which was already considered really freaking deferential. But yeah, I mean, it still kind of makes some sense, as I said. It's the agency that wrote the regulation. They should get deference to interpretation of their regulation. So then along comes the 2019 case of Kaiser versus Wilkie. This was a case involving VA benefits, and it was written by Justice Elena Kagan. Kagan, of course, being an expert in administrative law, having a ton of experience with it, more so than some of the other justices. She's a really brilliant writer, and the question came up of whether or not to overturn Auer deference, to get rid of it. So it could have gone the same way that Loper-Bright did when it overturned Chevron. And Elena Kagan decides not to do that. She decides we're going to keep Auer. But she does make sort of a compromise in the sense that her opinion makes Auer a little bit harder to get. Auer deference is not something that agencies can just easily get. So first, she starts off by saying that an agency regulation needs to genuinely be ambiguous, genuinely. So it can't just be something that is considered ambiguous in one way, but the court needs to exhaust all other statutory tools of interpretation to find that the regulation is ambiguous. So it looks like they're kind of saying the court needs to do some work here. And in that work, they could find that the regulation is not genuinely ambiguous. And at that point, it would essentially kill the prospect of getting Auer deference. Also, the agency interpretation still needs to be reasonable. So this is kind of channeling the Alito opinion in SmithKline-Beecham Corp., where she's like, okay, don't give us a nonsensical interpretation or you won't get Auer deference. It needs to really fit the character and context of the regulation, their interpretation does. So yeah, I mean, those are kind of commonly used words in the context of law, character and context. Courts like to use them a lot. But yeah, so she ends up getting a majority. Her view wins the day, but she of course gets a concurrence from Justice Gorsuch. Neil Gorsuch, of course, joining in 2017, a pretty solidly conservative justice, not quite as conservative as, say, Thomas or Alito, but he's like, no, I kind of agree with Scalia in 2011 when he said that there's a problem with enabling agencies to write vague regulations. This is a problem here. He thinks that Auer deference is inconsistent with the Administrative Procedure Act. He thinks that it's unconstitutional. So he concurs in the judgment, but he disagrees with Kagan, saying that Auer deference is going to be here to stay. He thinks not only should it be harder to get, but it should not be a thing to begin with. Chief Justice Roberts writes a concurrence where he sort of says that, hey, Gorsuch and Kagan, you guys, your views actually kind of have more in common than you would have thought. So this is currently the state of things. Yeah, Auer deference is a good bit harder to get. I mentioned Gorsuch's concurrence because his view might end up winning the day with the 6-3 conservative Supreme Court. Obviously, in 2019, Justice Ginsburg was on the court. Now she's been replaced with Amy Coney Barrett. So there's a pretty solid chance that Auer deference could be overturned if the case comes up again and if the case actually makes it to the U.S. Supreme Court. Anyhow, I hope you found this video helpful if you're in administrative law or you just want to know more about Auer deference. If you found this video to be helpful, please leave a like, comment, and subscribe. I would really appreciate it. Thank you.